Today, we are looking into a topic that is as complex as it is fascinating. Who really owns the land in Warri? This question has been a source of intense debate and legal battles for centuries. To find the answers, we can't rely on modern talking points or internet rumors. We need to go back in time, sift through historical documents, and examine key court rulings. So, let's embark on this intellectual journey together to understand the historical perspective of land ownership in Warri. Before the arrival of Europeans, the Niger Delta, like much of West Africa, had its own sophisticated systems of land tenure. Land wasn't typically seen as a commodity to be bought and sold by individuals in the way we understand it today. Instead, land was communally owned. Families, clans, or entire communities held rights to the land, which was managed by traditional leaders like chiefs or elders. These leaders acted as custodians, allocating land for farming, fishing, and living based on need and tradition. This system was rooted in ancestral claims and the idea that the land belonged to the living, the dead, and the generations yet to come. In the area that would become Warri, different ethnic groups, including the Ijaw, Urhobo, and Itsekiri, had their own distinct but often overlapping spheres of influence and settlement, each with their own customary approach to land. The story of modern Warri and its land disputes really begins to take shape in the 19th century with the increasing presence of European traders. The Itsekiri, due to their strategic position along the waterways and their early contact with the Portuguese, established a powerful kingdom with the Olu of Warri at its head. They acted as middlemen in the trade between the hinterland and the Europeans. By the mid-1800s, British influence was growing. In 1851, a significant event occurred when Consul John Beecroft signed a treaty with the leaders of the area. This was a commercial treaty, not a land cession. It was about regulating trade and protecting British interests. At this time, historical records show various communities living in the area. But the Itsekiri Kingdom was the dominant political entity interacting with the British. The real turning point came with the establishment of the British Protectorate. In 1891, the British administration, seeking a base of operations, entered into an agreement. This is a crucial point of contention. The Itsekiri maintain that their leader, Chief Dore Numa, acting on behalf of the Olu of Warri, leased the land, not sold it, to the British for administrative purposes. This land would become the nucleus of Warri Township. However, other groups, particularly the Agbarha Ame Urhobo and the Ijaw of Ogbe Ijaw, contest this narrative. They argue that their ancestors were the original settlers of these specific lands, and that Chief Numa had no authority to lease or grant land that did not belong to the Itsekiri Kingdom. They claim their communities were already established in areas like Agbasa and Ogbe Ijaw long before the British arrived and formalized the township. This set the stage for a series of legal battles that would span over a century. One of the most pivotal was the 1926 case involving Chief Ogegede, representing the Agbarha Urhobo, and the Itsekiri leader, Chief Dore Numa. The case went all the way to the Privy Council in London, which was the highest court of appeal for the British Empire at the time. The Privy Council's judgment is often cited, but its interpretation is at the heart of the dispute. The court ruled in favor of the Itsekiri, granting them ownership rights over certain parcels of land within Warri. However, the ruling also acknowledged the pre-existing rights of others, which many Urhobo families claimed to be. So the judgment affirmed Itsekiri overlordship, created by the European, but didn't necessarily extinguish the rights of those already living and farming on the land. This created a complex legal situation of landlords and tenants, a framework that has been challenged ever since. Subsequent court cases have further complicated the picture. In the case of Ijaw communities, particularly Ogbe Ijaw, they have consistently argued for their own ancestral ownership of the lands they occupy, separate from both Itsekiri and Urhobo claims. They point to their long history as a distinct community within the geography of Warri. For example, a 1970s Supreme Court case involving the Ogbe Ijaw and the Itsekiri community again dealt with these conflicting claims. The court's decisions have often been based on the evidence presented at the time, including colonial-era treaties, maps, and oral histories, which can be interpreted in different ways. The courts have tried to balance historical realities with legal principles, but this has rarely led to a conclusion that satisfies all parties. Each group holds up the court judgments that favor their position while questioning the ones that don't. So, analyzing the data from a neutral standpoint, what can we conclude? First, it's clear that before colonial intervention, land tenure was communal and based on settlement and use, not on legal titles and documents. Second, the Itsekiri Kingdom, through its political structure and relationship with the British, was able to secure legal recognition of its overlordship over large parts of what became Warri Township. The colonial administration found it more convenient to deal with a single, recognized authority. Third, the court rulings, from the Privy Council down to the Nigerian Supreme Court, have consistently affirmed this Itsekiri overlordship in a legal sense, based on the treaties and agreements made with the British. However, and this is a critical nuance, these same rulings often acknowledge the customary rights of other groups as long-term inhabitants. This creates the fundamental conflict, the clash between legally recognized ownership or overlordship held by the Itsekiri and the deeply felt ancestral and occupancy rights claimed by the Urhobo of Agbarha and the Ijo of Ogbe-Ijo. It's a conflict between two different concepts of ownership, one based on legal titles and treaties, and the other based on history, ancestry, and continuous occupation. Neither side is fabricating their claims. They are simply proceeding from different historical and legal premises. The documents show a lease to the British, facilitated by the Itsekiri leadership. The oral histories and physical presence show long-standing Urhobo and Ijo communities. Both can be true at the same time, and that is why this issue is so intractable. It is not a simple matter of one group being right and the others wrong. Rather, it is a complex tapestry of overlapping histories and competing legal frameworks, all layered on top of each other by the disruptive force of colonialism. Understanding this history is not about taking sides. It's about appreciating the deep, multifaceted roots of the issue. The identity and heritage of all these communities are tied to the land in ways that transcend simple property law. To move forward, any solution must acknowledge the validity of these different historical perspectives. It requires looking beyond the winner-takes-all approach of the courts and finding a path that respects the history, rights, and dignity of all the peoples who call Warri home. This has been a very brief look into an incredibly deep and sensitive subject. There are countless more documents, court cases, and historical accounts that add even more layers to this story. What are your thoughts on this? Do you have family stories or knowledge that shed more light on this history? I encourage a respectful and intellectual discussion in the comments below. Let's learn from each other. Thank you so much for joining me on this historical investigation. If you found this content valuable and want to see more deep dives like this, please hit that like button, subscribe to the channel, and turn on notifications so you don't miss our next video. Your support helps us continue to explore these important topics. Until next time, stay curious.